Dear students, this is Harinaganand Idumudi, English Shorthand Instructor. If you want to get more updates, please subscribe our channel. Our channel name is Shorthand Hub. If you want to join in my WhatsApp group, please send a message to 970-4455-002. You are watching my video on Legal Shorthand Shadab. Now I am going to dictate a passage relating to legal at 100 words per minute for all examinations including High Court and District Courts. 5 seconds. Start. The present writ petition is filed questioning the award dated 24/10/2000 in ID 96 of 1997, whereby though the Labour Court reinstated the petitioner into service by modifying the punishment of removal from service inflicted on the petitioner by disciplinary authority. Though order dated 4/1/1997, the grievance of the petitioner is that by way of modification of punishment, deprivation of 3 annual increments with cumulative effect is disproportionate to the gravity of the charges said to have been proved against the petitioner. The facts in brief are that the petitioner joined the service of the respondent corporation in 1990. While he was in service, he absented himself from duty from 4/10/1996 to 24/10/1996. Treating this as unauthorized absent, the respondent corporation initiated disciplinary proceedings against the petitioner and eventually, through an order dated 4/1/1997, removed the petitioner from service, holding that the charge of unauthorized absent was proved and that as it was a major misconduct. Later, when the petitioner took the matter before the Labour Court by raising an industrial dispute in ID number 96 of 1977, the original order of removal from service was modified by the Labour Court, directing reinstatement of the petitioner but subject to denial of annual increments for a period of 3 years with cumulative effect on such reinstatement. Hence the writ petition. Land Council for the petitioner has submitted that the petitioner had a valid reason for his absence for 20 days and that soon after his reporting back to duty, the petitioner produced the necessary proof with regard to the cause for his absence. Despite the cogent explanation given in that regard, the disciplinary authority in a mechanical manner imposed the capital punishment of removal from service on a mere excuse of absence, which is unconscionable apart from being grossly disproportionate. Per contra, the Understanding Council for the Respondent Corporation has contended that the disciplinary authority and the Labour Court have concurrently held that the misconduct of unauthorized absence has been proved. He has further submitted that the Labour Court, having accepted the findings, chose to interfere on the principles of proportionality. The Understanding Council has contended that unauthorized absence is a major misconduct and that it is the corporation that has been aggrieved by the award of the Labour Court. According to the Learned Standing Council, only with a view to giving quietus to the issue and also to give one more opportunity to the petitioner to mend his ways, the department did not choose to lay any challenge against the award of the labor court. In any event, the respondent corporation hasn't chosen to file any counter contesting the claim of the petitioner as was set out in the writ petition. Thus, taking into account the submissions of the Learned Standing Council and based on the material available on record, the issue shall be decided. Indeed, in terms of the regulations of the corporation, any unauthorized absence would be treated as a major misconduct since it would have consequences of dislocating the work of the corporation. Be that as it may, the question that falls for the consideration before this court, as it has fallen before the labor court, is whether the punishment inflicted on the petitioner is proportionate to the charges said to have been proved against the petitioner. Stop.